The subject of this video will be the possible testimony of Donald Trump in the ongoing E.Jean Carroll defamation trial, where the sole issue to be decided by a jury is the amount, if any, of damages that will be awarded to Carroll. I'm going to discuss whether that is advisable for Trump to testify and what he may be trying to do in the event he does testify. To address those issues, I need to place them in context. A jury has already returned a verdict that Trump defamed Carroll by claiming she lied about Trump sexually assaulting her in a department store dressing room. That trial involved a statement Trump made in October 2022 when he was no longer president. The current trial relates to the same statement made by Trump in 2019. There is a long-established legal doctrine called collateral estoppel that prevents parties from relitigating an issue that has already been decided by a jury. The jury in the prior case returned a verdict finding that Trump had sexually assaulted Carroll and had defamed her by calling her a liar when she made that claim. So, when Trump has made the same kind of statement on another occasion, besides the one in October 2022, which he is precluded by the doctrine of collateral estoppel from relitigating whether the statement is legally defamatory. That is why the current lawsuit is only about damages. Without that doctrine, the court system would be clogged with parties relitigating the same issue over and over and over again that have already been decided by a jury. So there needs to be finality to a jury judgment on an issue. Trump is not going to be allowed by the judge to testify that Carroll had concocted the allegation of his sexual assault or has done so for financial or political reasons. Since the defamation issue has already been decided, he can testify why he made the statement that she lied, a fine line to draw. That testimony, if properly restricted, would be allowed on the issue of punitive damage and whether punitive damages should be awarded. To award those damages, a jury must find that Trump's statements were wanton or malicious, bordering on criminal, before awarding Carroll punitive damages. It would be a bad idea for Trump to take the stand and testify on that matter, since it would open him up to cross-examination on every statement that he has made about Carroll, other than the ones made in 2019 and 2022 that were the subject of the two defamation trials. That would most likely, in my opinion, add to a potential punitive damage award rather than negate one. It would put an exclamation mark on what Carroll's attorney said in her opening statement. She asked the jury, how much money will it take to keep Donald, a, quote, self-proclaimed billionaire, end quote, from continuing to defame Carroll, a statement that goes directly to the punitive damage award. So from this angle, it is counterproductive, in my opinion, for Donald to testify. So why would he do it? The first possible reason is that he will cross the line intentionally in his testimony and attempt to relitigate the liability issue on defamation. The judge would then give him a quick warning about doing that, and if he continued, possibly hold him in contempt or even terminate his testimony, since he was violating a court order on what was permissible testimony. Trump would then go to social media and make statements in the press. There will be the usual false or misleading claims that he normally makes. And he would then raise millions from mom and pop Republicans who buy into Trump's grievances as valid. The second possible reason assumes that Donald can control himself, which he has been unable to do so far. The testimony would be carefully tailored by him and his attorney to stay within what is permissible on the punitive damage issue, but is nonetheless designed to convince one or more jurors that he is the victim, not Carroll, and to refuse any award for damages for that reason. In other words, a backdoor effort to relitigate the liability issue through testimony on the punitive damage legal standard. This could work with a juror who is already sympathetic to Trump's claims of being the victim. It would backfire in a huge way for reasons that I discussed earlier, that is, vastly increasing the punitive damage award well into the millions, possibly the tens of millions, since it is even more apparent that a large award is necessary to keep him from continually making the same defamatory statement over and over and over and over again. Just from looking at this case from afar, the best defense may be to convince an appellate court to overturn the prior jury verdict on defamation. And if that happened, the liability judgment in the current case would go by the wayside. The attack on the first verdict would probably be centered on the evidence that the court allowed the jury to hear, which may not find a receptive audience in the appellate court. I'm referring in part to allowing the jury to view the excess Hollywood tape.